cases where the central issue is ineffective assistance of counsel, and if you're familiar with the law, you sit there and think, well, what could this lawyer have been thinking? Because it's obviously reasonable performance, or it's obviously not harmful, which are the requirements to make that kind of claim. And I think the answer is the poor lawyer had nothing else he could argue, so he had to, reach down, grab his bootstrap, grab his shoelaces and lift, and that we have ineffectiveness claims filling this void that's left by our inability to file Andrews briefs. But if you are in the desirable position, the enviable position of having a number of viable claims or a number of issues in the case, then as Chris indicated earlier, it really is really behooves you to apply some selectivity to them. And I think somebody earlier, Robert earlier mentioned Jones versus Barnes, the case that sort of stands for the lawyer's prerogative to select the issues. And in the course of Jones versus Barnes, the court talks about the desirability of selecting the issues. And any lawyer should be able to look at a case and look at the issues and think to himself or herself, that if I can't win on this issue, I'm not going to win on the others. Well, why waste time and resources with all this? I mean, obviously this, the level of discrimination, if you've got 2 good issues, raise 2 good issues, maybe 3 good issues. But as Chris indicated, you're lucky if one thing went wrong in the case that warrants reversal. And you lose some credibility when you're coming in and trying to tell the court that, that 3 terrible things happened, or 10 terrible things happened, that you lose the court's confidence and you lose their attention. And, these single issue briefs, there's nothing wrong with single issue briefs. In fact, that actually, I think, reflects a lawyer who's highly discriminating and who is in effect promising the court that she's not wasting its time. Anybody else want to say something?
Yeah, I wanted to grouse about Andrews' motions as well. I mean, I think the right way to do an Andrews brief when you have the opportunity to do it is for that to be a catalog of every conceivable issue, and of lines of authority that would have to be overruled in order for the defendant to prevail on those issues. And sometimes that's what I've done, and what I have thought of as disingenuous Andrews motions, where I've written a brief that says you should rule X, and in the course of it you should overrule all these cases. I do that 6 or 7 times, and the court kind of knows where you're going. And the concern I've got about the prohibition on Andrews motions is that wink and nudge. A few years ago, a friend of mine who recently become a judge in the Court of Appeals commented to me that the advice that had been given on coming onto the court was, never grant oral argument when they're arguing insufficiency of the evidence. The reason for that is that it is argued so very often, as Jim indicated, in cases where it's got absolutely no merit. And of course, that stung because about that time I had been representing somebody who I bore you with the story I can tell you at 3 a.m. But the evidence was insufficient. But the court didn't pay particularly good attention to the issues and didn't give me oral argument and affirmed it. I will say that my client, who was convicted of defrauding her former employer, continued paying on her bill after she served her time in prison.
We'll say, I'll make one comment with regards to the Andrews issue, which is, I sort of have somewhat of an opposite feeling about it. I've oftentimes picked up cases, read through them, looked at all the materials, and thought, there's no way in hell I can win this case. I have no issues at all. I don't see anything. And I put it down, and then I go back to it, and I plow through it some more. Because I know I have a motion for new trial, and I have to argue something. And I don't like arguing to a judge and not making some sort of sense. I don't want to look look stupid. So it makes me work extremely hard searching a record for something. And there have been cases that I said where I looked at it and I went through it and I said, there's no way I can win this case. This evidence is overwhelming. There are no good issues. And lo and behold, when I dug in and went back through it, I ended up winning some of those cases. So that's sort of the flip side of the no Anders briefs. It just makes you work doubly hard because you got to say something.
I would just like to say one other thing, looking at my notes that I forgot. When you were selecting issues, there are actually other things that come into play other than just the merit and the viability of the issues. You know, you might want to think about such things as the whether you've got a theme, and you might have several issues in a theme, and one that is marginal, that is not in that theme, and it would kind of disrupt the thrust of the others. And you know, that's a consideration that you might want to take into mind. Perhaps leaving that that odd issue on the cutting room floor. You might have issues that actually undercut each other, and frankly, ineffective assistance is one of those. Suppose, for example, that you've got a trial lawyer who did something absolutely brilliant. You know, made a sound argument. It's the issue you think's got the best prospects, preserved the record, and did everything right. Well, you don't want to enumerate that as your first issue, and then you have your second issue. And by the way, my lawyer was an idiot. You know, that's undercutting. You're undercutting yourself to include you know, particularly if it's a poor or a contrived ineffectiveness claim. You know, you don't, and you can raise it, but you wouldn't want to because it's actually getting in the way of an issue that you know that's got better prospects. So things like that kind of fit into it. Another thing is too whether you want to restrict the other side's argument. You know, if you throw in a losing issue or an issue that makes you uncomfortable, you're giving the other side a chance to make the case about that rather than the issues that you would like to restrict the court everyone's attention to. You know, I always you know use it as a personal rule. I don't want any issue in the appeal that the other side's going to enjoy more than I did. And so anyway, those are the factors that go in. Of course, the overarching one is the legal merit of it. Anybody else have any thoughts or comments?
No other
I think
questions?
we're on budget.
Okay, here we go.
Oh.
Yeah, I've got one very practical question, and it's practical from the point of view that you understand that we're talking about having our associates who already are very, very busy volunteer to do these cases. And that is to meet with the client to discuss what the issues might be that the client wants to raise, or if the client knows of some witness that wasn't called that he thinks should have been called. And also just to meet with the client just for the human reasons. Where are they? Are they still in the county jail until a motion for new trial is decided, or could they be anywhere in the state prison system?
They should be within the county, but they might very well not be. Steve, probably.
Most of the time, in my experience, they're shipped out, in full, particularly in the metro area. I mean, the Fort County jail is very overcrowded. They're trying to get them out if they're going to the state system as quickly as they can. And technically, you can file, you know, somebody could have filed a motion to try and keep that person in the county jail. But by the time I get the majority of my cases, they're already long gone. So
Yeah, I mean, the law is those motions, you can't have in the county jail filed by the lawyer, and the lawyer asserts that I need them there so they'll be available for your consult. You got a right to have that granted. That and a couple bucks will get you a cup of coffee.
Yeah, a lot of times you're trying to do that after they've been transferred, and that's a different proposition. I might add one thing too, Bill. Most people don't like to be in the county. If given the choice, they would prefer to be in prison too. So I don't know if that's answered. I guess the answer to your question is they could be anywhere. the thing that I would suggest of talking about meeting them, you know, in an ideal world, we would take care of all those courtesies and we would do that. But, you know, the most productive meeting is going to be one when you are somewhat you know, are pretty familiar with the record. And it's just like talking to the lawyer involved. You know, you don't want to talk to him until you know the questions you're going to ask and the issues you're going to touch on, because you're probably only going to get to talk to him once or twice. Yeah.
So it doesn't have to do with the appellate checklist, but it does have to do with visiting your client who's incarcerated. I have very limited experience in doing that. The topic sometimes needs change from your appeal to all sorts of other legal issues that they might have, either with their incarceration, you know, like where they are, or with their family, with child support, with just a whole host of many heartbreaking problems that happen when you get put to jail. Are there agencies that have their own staffs of whether it's, I don't know, I mean, what do public defenders do when they get this kind of just normal legal problems that are outside of the criminal conviction seem to help these people out?
Well, it kind of depends what the nature of the problem is to some extent. I mean, if it's some sort of condition issue where, you know, they're being threatened or they're in danger, issues like that, something, you know, fundamentally wrong with the place that they're at, and there are numerous groups that do, you know, litigation on behalf of prison conditions and stuff like that. So those groups are not too hard to find. You know, I've never had people talk to me about child support, but, you know, Atlanta Legal Aid, I guess, would be where I would direct them if they had some issues with families. There are, you know, departments within the Department of Corrections that families can work through to, you know, resolve issues about where people are located. Sometimes people want to be in the county jail because their family can't visit them if they're down in South Georgia somewhere. Other times they don't want to be anywhere near the county jail because they have to share cells with body. It's just horrible. They've been there for a long time.
The root of most of those problems is the fact they're convicted and confined. And a lot of times the rejoinder you have to that is that this is the root of your problem. This is my commission to work on that. You know, I recognize the problem of your family being evicted, but, you know, I don't think you really want me to spend the limited resources that I've got to go to your case to do that. You know, that's not the most effective use of my, you know, that kind of thing. So you have arguments like that, and I think most people would understand. I mean, it's a terrible thing because there's so many of those, you know, consequences. I mean, first of all, you've got a very unhappy camper anyway. And then on top of that, you have all of these, I mean, you probably had a lot of these problems before they went in, medical, domestic, immigration, you know, Lord knows. And being confined, of course, doesn't help any of those. Doesn't help their disposition either, you know. But I think most people understand if you say, look, this is what I can do. I can work on knocking the conviction out. And this is really what I think you want me to do.
I just wanted to add, going back to the issues, related to the jury instructions, also pay attention to any juror questions and any recharges by the court. That may be an area where we could pick up some issues.
Were there any other questions? We saw almost cut off that.
And the panel members will still be here. We're going to have a great presentation during lunch from the clerk of the Court of Appeals. Mr. Martin is here with us, but these panelists will be around. And again, you know, this is a lot of information in one setting, and so, you know, we'll be available. We'll make ourselves available to follow up on this and give you as much information as possible. I don't think there's any, we don't assume that you're going to get everything in one day. So if there are no further questions, what we'll do is we'll take a break to get our meals. I think we have about 15 15 minutes to get all your